I will read the presentation of my colleague, as Professor announced. The presentation was written by the author, lecturer Diana Cirmaciu from Orodea, from Romania. The title is Considerations Regarding the Taxation of the Religious Cults in Romania. Information often appears in the public space that the Church does not pay taxes. In this context, we propose a brief analysis of the relevant fiscal legislation in the matter in order to clarify the fiscal status of religious cults. The subject addressed can be considered a sensitive one, but the presentation of the factual and legal situation is necessary to understand the legal-fiscal relationship between the state and religious cults in the context of religious freedom and the general regime of religious cults. The Church had and continues to have an essential role in society, being an institution that has survived many political systems. In our country, Romania, it is considered an element of continuity and this winding path of Romania. Moreover, let's keep in mind that all religious cults have a distinct role and influence even in the economic sphere, being able to exemplify in this sense the historical buildings owned by them, which do not only fulfill the function of a place of worship, but are often true points of tourist attraction, hence a series of economic consequences. Due to the complexity of the topic of taxation of church assets, it is necessary to start from a few legal benchmarks, a national and European perspective, which will allow us to a better understanding of a specific fiscal relationship in this area. In the public space, there are frequent debates that address the issue of financial support given by the Romanian state to religious cults, topics about the Church as taxpayer, the normative framework, and the situation of restitution of properties that belong to religious cults in our country. The state, recognizing the spiritual but also the educational, social, and charitable role of religious cults in the life of Romanian society, tries not to tax such as an important social partner. This treatment is applied in any democratic state, especially where the moral quality of religious cults has been proven in times of social crisis. Although religion and taxation seem to come from totally different fields, each with its own specific way of definition, organization, and operation, it is noted that fiscal policy can be influenced by the constitutional relationship between certain states and cults, especially in the case of state churches, which benefit, based on this legal status, from a special fiscal status. And also the fiscal regime can influence the life of a cult, especially in its secular dimension, for example, possession and administration of assets, carrying out activities with patrimonial value, self-financing methods. In specific terms, cults and fiscal policy relate and influence each other. In other words, cults and fiscal policy are mainly influenced by the social, cultural dimension of religion, an aspect retained at the level of the Romanian state according to the law of cults. Given that, in a general sense, fiscal policy is, I quote, the art of determining the general characteristic of the tax according to the economic, social, and psychological data provided by the society. I ended the quote. It means that the current Romanian fiscal system, including the field of cults, is designed to meet the requirements imposed by the national specifics of socio-economical policies, at the same time considering Romania's quality as the EU member state. A fiscal harmonization with the fiscal systems of the other member states is required. In the context of the considerations mentioned above, the framework for the wording of the fiscal policy in the field of religious cults in general, and with regard to places of worship in particular, is determined by: the first element is the national competence of the European Union member states regarding the regulation of religion. The second one is considered the constitutional legal definition of the relationship regime of the Romanian state with all the cults recognized by law. The third one is the social-cultural profile of Romanian society. And the last one, the fourth one, the role of the place of worship in the manifestation of the right to religious freedom in its collective dimension and public manifestation. The national competence of the European Union member states regarding the regulation of religion. In relation to the EU treaties, according to the principle of subsidiarity, the regulation of religion is left to the level of the member states in accordance with the constitutional, legal, and political traditions of the member states. My colleague is quoting here some articles of law which you will probably see in the paper published. This is because the European Union recognizes and respects the, I quote, cultural diversity of the member states and the traditions, I ended the quote, as a source of fundamental rights. The European Union explicitly emphasizes that it respects the customs of the member states regarding religious rights and does not affect the status enjoyed under national law by churches and religious associations or communities in the member state while recognizing their identity and specific contribution, as long as the fundamental right to religious freedom is respected and religion does not become a form of discrimination. In the light of European legislation, each European state member is guaranteed the right to traditionally regulate its relationship with the religious structures present on its territory, that is, to take into account, first of all, its specific in terms of its own history and specific realities. Implicitly, not all member states have created the same system for the state-cult relationship, although they have ratified international legal instruments that provide for the right to religious freedom and the freedom of consciousness, provisions that also appear in the constitutional texts of the respective states. The European Union does not impose a specific model, but it is up to each state to create its own legislation, which is applied to religious structures. Exceptions granted by the Law 227 from 2015, Fiscal Code. As a consequence of the way in which fiscal policies are made, the current fiscal code brings together the general principles of Romanian taxation, the relationship between Romanian law and international treaties on taxation, including double taxation, avoidance conventions, respectively, the main taxes and fees in the Romanian fiscal system. With regard to places of worship owned by recognized cults, the current fiscal code provides for exception from paying building tax and building charge, land tax and land charge, fees for issuing certificates, approvals, and authorizations. At the same time, in order to maintain and operate the places of worship, the cults, according to Article 399, Paragraph A, letter K, Fiscal Code, can benefit from certain exemptions for energy products and electricity. Regarding the definition of the place of worship, the Fiscal Code retains in Norm 23, Paragraph 1 that by the phrase buildings which by destination constitute places of worship, churches, places of worship, houses of prayer, and their annexes are understood. The term lăcaș in Romanian is a variant of the term locaș. Church annexes refer to any premises that have the constituent elements of a building, the property of a cult recognized by law or a religious association, such as the bell tower, the parish chancellery, the mortuary chapel, the premises for lighting candles, the barn, the troița, the warehouse for storing various objects of worship, the settlement with a social charitable character, the cell, the refectory, the premises for carrying out activities of an administrative ecclesiastical nature, the tenant's residence, as well as the like. The criterion chosen by the state in defining places of worship is that of the destination, and in order not to give too broad an explanation, an exemplary enumeration is carried out. Places of worship, sacred assets, intangible, imprescriptible, and inalienable real estate. By virtue of the considerations stated in the previous chapter, the Romanian state, through specific legislation, gives the right to recognize cults to own and manage buildings in accordance with their own statutes and regulations as an expression of freedom of religion, a freedom that allows with a special status as sacred property of places of worship in relation to the teaching of a particular cult. These aspects are also recapitulated in the jurisprudence of the High Court of Cassation and Justice, which appreciates that the granting of the qualification or classification of a building as a sacred property is done by religious cults according to their own criteria, retained by statutes, regulations, and canonical codes by virtue of autonomy, starting from the tradition and practices of the respective cult. Given the fundamental importance of the place of worship, a sacred property par excellence, in the architecture of the profession of religious freedom, the State Secretariat for Religions keeps a clear record of these constructions with special status. Since the legal characterization of places of worship is done by reference to the notion of sacred property, it follows that places of worship are, as she mentioned, inalienable, imprescriptible, and I don't see it, it's again repeated. An aspect expressively retained by the law of cults in Article 27, paragraph 2, and specifically in the BOR, that is the Romanian Orthodox Church Statute. Since the immovables that have the attribute of being inalienable are not in the civil circuit and implicitly cannot form the object of any civil act, it follows that the places of worship having the quality of sacred property and not being able to form the object of any legal act are not subject to taxation, since each tax or charge is individualized through a title of budgetary fiscal debt, defined as an individual legal act which establishes the extent of the obligation towards the state of the natural or legal person. At the same time, since in the field of immovable property, the object of taxation is the value of the building and the exemptions operate by reference to the object of taxation and not to the subject of taxation, that is the owner, the exemptions provided by the fiscal code for places of worship are based on the fact that the taxable matter, the buildings, are not included in the tax base. Places of worship, spaces of public utility. The law on cults expressly states, recognized cults are legal entities of public utility. In the conditions in which the state defines the recognized cults by virtue of the attribute of public utility of their activities, it is obvious that the status of public utility primarily characterizes places of worship, spaces intended for these activities. Given the public services aim to satisfy social needs through specific means and according to the principle of satisfying the public interest, it follows that the authorities legitimize the ownership and destination of places of worship in the key of public law. However, under the conditions in which the regulatory object of public law is aimed at public administration authorities of a state nature, it follows that the status of value of worship owned by the recognized cults, legal entities under private law, has similarities but also differences with respect to the status of goods in public ownership. Moreover, the fact that places of worship are legally imperceptible, imprescriptible, and inalienable means that they enjoy a legal regime close to that of goods that belong to public property, a similarity that also generates a similar fiscal status. Taking into account the social partnership and by virtue of the public utility character of the recognized cults, the Romanian state understands to support them with regard to places of worship, both directly with a view to their construction, repair, restoration, and maintenance, as well as indirectly, granting fiscal facilities in this sense. Since the fiscal policy in the field of cults is formulated, interpreted, and applied according to the legal status of the respective cults, and given the characterization and attributes of the relationship between the Romanian state and the recognized cults, it goes without saying that the exemptions from paying the tax on the places of worship is a consequence of this reporting. Let's also bear in mind the fact that, according to the studies carried out by the State Secretary for Religions, mostly in most European states, one form or another of financing tax exemptions for places of worship operates. Given that the perspective of the Romanian state regarding places of worship is one of encouragement, ownership, and administration, these being generally spaces dedicated to the organization or support of activities of public utility, fiscal policy cannot make a discordant note but subscribes to this objective and presupposes the granting of tax facilities. Tax exemptions of places of worship, legal tradition of the Romanian legislator. The qualification of places of worship as spaces intended for activities of public utility and implicitly granting them tax benefits is a consistent perspective of the Romanian legislator since the formation of the modern Romanian state, establishing itself as a legal tradition. The consistency of granting fiscal facilities for places of worship, despite all the differences in the political regime that have governed the Romanian state for at least the last 150 years, is an attribute of the legislation in the matter, which summarizes and enshrines the reasons by virtue of which the buildings that have the destination of places of worship, sacred goods fundamentally serving the organization and manifestation of freedom of religion, accepted and defined as an activity of public utility, benefit from the exceptions from paying property tax. And I will present you some conclusions. Any dissemination in the public space of false information that the Church does not pay taxes is harmful and seriously distorts the public debate on the relationship between the state and religious cults. Religious cults have a similar fiscal status to NGOs, political parties, unions, universities, that is, the funds that circulate within the organizations are intended to strengthen the organization and facilitate its proper function for the benefit of the society in which it operates. Thus, the state understands to facilitate the citizens' exercise of religious freedom, just as, for example, by not taxing the donations and contributions of members of political parties, the state facilitates the exercise of political rights and opinions. In the case of trade unions, the exercise of social rights. All religious cults recognized by law in Romania benefit from fiscal facilities and not fiscal privileges, as an expression of the democratic regime in which citizens are encouraged and supported to exercise their rights and freedoms, among which religious freedom is one of the fundamental ones. No democratic state exerts unnecessary fiscal pressure on civil society organizations precisely because they fulfill their vocation and mission without the intervention of the state. The only incomes of religious cults in Romania and in the European Union area that are exempt from taxation are those from the sale of objects of worship and contributions, not taxes, for weddings, baptisms, and other religious services which are not commercial activities. Receipts are and must be issued for these contributions. The funds from these sources, intended to support self-financing, remain exclusively in the internal circuit and are reinvested in the maintenance and repair of places of worship, as well as in numerous social philanthropical activities. The Church paid tax on buildings and land in use, on the salaries of employees, and here we remind the clerical and non-clerical staff, as well as on any income obtained from an economic activity if the funds resulting from the activity are not directed to social philanthropical works, religious, educational, or cultural. All commercial or economic contracts concluded by the Church with third parties are subject to taxation if the surplus money is not directed to the repair and maintenance of places of worship or to works of the nature of those mentioned. Religious cults are taxed by the state and benefits from certain tax facilities, just like any other civil society organization, including for the effort and capacity of religious cults to integrate over 99.8% of the resident population of Romania. And last but not the least, regardless of the number and size of properties confiscated by the state over time, starting with the regime of Alexandru Ioan Cuza, one of our Romanian rulers, and culminating with the communist regime, the subject of retrocessions has to do with the reconstitution of the fundamental right to property and must not balance with that of fiscal facilities. The Church deserves to maintain a tax status similar to that of the other social society organizations, based on tax breaks, not privileges, whether or not all confiscated property is returned. Thank you so much.